Hello and welcome you again to our YouTube channel. This is Kartavya IAS Institution. We are providing you free courses for the Union Public Service Commission and other state public service commissions, right? Your GS, particularly GS paper comprises four papers, namely paper 1, 2, 3, 4. And in that particularly GS paper 2, I am dealing with, my name is Liaquat Hussain, you know well, and you may be familiar about me. We have started a kind of initiative to provide the free courses for the GS paper 2. Particularly if we talk about the GS paper 2, it comprises 5 topics or 5 subjects: the polity, constitution, governance, social justice and international relations. So these 5 chapters or 5 topics collectively constitute your GS paper 2, right? In that, particularly for polity and constitution, nowadays we have started a video series, and on regular basis we have been providing you the videos on the same topic, right? And one more thing I would like to inform you here itself, that this prestigious institution is run under the guidance of Honorable Dr. Kumar Mayank sir. He is an eminent faculty for the economics. He is very renowned across the world for the economics. And if any one of you want a kind of advice or the instruction on the economics, then you can subscribe our channel. On the same channel, the videos are available. You can directly connect to the sir, right? The other kind of information like contact number, email ID and other access points are given in the description section, right? So let's get started and try to continue our video series which we have started. You see here, I have written here for you the center-state relationship. But what is the center-state relationship? We started a center-state relationship. 2 previous videos we have done on the same subject. If we try to talk about the center-state relationship, then we try to understand the center-state relationship on 3 heads. 3 broad categorization we tried to do about the center-state relationship. Center-state relationship has a lot to do with the concept of the federalism. We try to understand federalism in detail. We have done a whole video on the federalism, right? You go and watch our video on the federalism. So we are a federal country. The division of power is there, the center and state government derive directly their authority from the constitution itself, right? They are independent in their domain. But at the same time, we understood that our federation is not ideal type of federation. It is a kind of federation with unitary bias or unitary tendencies. This is also reality. And in that background, we started understanding the kind of relationship which is there between the center and state government. So you see, on 3 fronts, we tried to understand the center-state relationship. Particularly, the first one was the legislative relationship. The second one was administrative relationship. And the third and the last one was the financial relationship, right? Which kind of relationship center and state government share as far as the matter of the legislation or the law making is concerned. So it's very simple. We have understood this thing, the legislative relationship of in between the center and state in detail, and we try to understand that which kind of legislative relationship, the territorial area we did. You see here the territorial extent through on which the center and state enjoys power to legislate. Legislative subjects, we did the center list, union list and state list and concurrent list, union list, state list and concurrent list. Parliamentary legislation in state field, at many instances we try to understand, at so many instances, that parliament can make laws on the state list. We have understood well this also. Center's control over state bills. State is making laws, and in that particular scenario, the center is having authority. Center can control the state bills. Which kind of mechanisms are there to control, to exercise the control of central government on the state bills? We have understood in detail in our previous video, right? And at the same time, parliamentary legislation in the state field or in the state list. Parliament makes laws on the state list, right? Very often there are circumstances when parliament makes laws on the state list. Legislative subject territorial extent. So this all we have understood well, right? So The legislative relationship we have understood well. Now today we are going to do administrative relationship or executive relationship, right? Administrative or executive relationship. So let's try to understand, as far as the administration is concerned, as far as the execution is concerned, which kind of relationship is shared between the state and the central government. So I have written here for you, you see administrative relationship or executive relationship. If we try to talk about the article particularly 256 to 263, this much of article talk about the executive or the administrative relationship between the center and state. And part 11th of the constitution, you know well, right? So let's get started and try to understand each of these factors which I have written here for you. Distribution of executive power. Let's try to understand the distribution of executive power. ये जो executive power है इसका distribution किस तरह से किया गया है केंद्र और प्रदेश सरकार के बीच में. You know well, our union government or the central government enjoys exclusive power to make laws on the union list. Is it clear? एंड वो यूनियन जो हमारा सारा टेरिटरी ऑफ इंडिया है उस पर वो लॉज एप्लीकेबल होंगे, तो उस पर उनका एक्सिक्यूशन इंश्योर किया जाएगा. एट द सेम टाइम स्टेट गवर्नमेंट्स इंजॉय पावर टू मेक लॉज ऑन फॉर द स्टेट लिस्ट. स्टेट लिस्ट के ऊपर स्टेट गवर्नमेंट्स कानून बनाएंगी, ठीक है, ये एक नॉर्मल सिनेरियो है. व्हाट एंड द स्टेट गवर्नमेंट्स आर वेस्टेड विद द अथॉरिटी टू इन्फोर्स दैट लॉज ऑल्सो. जो कानून उन्होंने बनाया है स्टेट के डोमेन के अंदर, स्टेट की टेरिटरी के अंदर, स्टेट गवर्नमेंट इज वेस्टेड विद द अथॉरिटी टू इंश्योर द इम्प्लीमेंटेशन और द एडमिनिस्ट्रेशन ऑफ दोज लॉज. ओके, इट्स फाइन. व्हाट अबाउट द मैटर्स व्हिच आर देयर इन कंकरेंट लिस्ट? About the concurrent list, we have understood that on concurrent list union as well as the state government can make laws together, right? वो दोनों के दोनों उस पे कानून बना सकते हैं. Who has power to ensure the enforcement of the laws which has been made on the concurrent list? concurrent list के ऊपर जो पार्लियामेंट ने कानून बनाया है और या तो स्टेट गवर्नमेंट ने जो कानून बनाया है उसको इन्फोर्स कौन करवाएगा, उसका एग्जीक्यूशन कौन इंश्योर करेगा, उसको एडमिनिस्टर कौन करेगा? Then the answer will be the state government. Be clear, ये यहाँ पे क्रक्स है, ये यहाँ पे थोड़ा सा एक ट्विस्ट है, तो ट्विस्ट को आप समझने की कोशिश करिए. The state government is vested with the authority to ensure the enforcement or the execution of the laws which has been made either by the parliament or by the state assemblies on the concurrent list matter, right? You see here on the concurrent list state governments are vested with the authority in ordinary circumstances. If otherwise is not provided, if the parliament has made laws on the matter of the concurrent list and parliament is explicitly telling that this matter is going to be executed or administered by the central government, then only central government shall ensure the enforcement or the administration or the execution of that particular order or the law. Otherwise, if parliament is not explicitly clarifying that who is going to govern this law, who is going to ensure the enforcement of this particular law, who is going to ensure the execution of this particular law, then by default the laws which has been made on the concurrent list either by the parliament or by the state assemblies shall be enforced by the state assemblies. Be clear about this, right? So this much we understand distribution of executive power. Hope you understand. On union list matter, the union government is vested with the authority to ensure the execution or the administration. What about the state list? The state government is vested with the authority to ensure the enforcement. And about the concurrent list, the state government has got the authority by default if otherwise is not provided by the parliament. Okay, let's move ahead and try to see here the obligation of center and state. Center and state government, there is some kind of obligation between the center and state governments. Let's try to understand which kind of obligation is that which is there between the center and state government. Compliance with the parliamentary laws. The state government, while making its laws, shall ensure the compliance of the law with the parliamentary laws. State government cannot make any laws which is in contravention or derogation with the parliamentary law, right? State government must ensure this. At the primary stage itself, state government's laws or the legislation or the regulations or the rules, nothing, or notifications, nothing can go against the spirit of the parliamentary law. This is must requirement, right? The first we understand. The second, while framing the law in the state assemblies, the laws framed by the state assemblies shall not impede or prejudice the executive power of the union government, right? When state assemblies are framing laws, they cannot impede the executive power of the parliament or the central government. तो जब स्टेट असेंबलीज कानून बना रही है, दे कैन नॉट बी प्रिजुडिस्ड और दे कैन नॉट impede, they cannot create hindrance in the path of the executive power of the central government. While formulating laws, while enacting policies, they must be clear that their laws must be in consonance with the parliamentary laws, number one. And number two, their laws should not impede or should not be prejudiced against the executive power of the union government, right? These two things the state governments needs to confirm, needs to abide by, right? Article 356, you know well, president rule. And Article 365 is about state fails to comply with any direction. When a state fails to comply by any direction of the union government or the union, central government, then President of India assumes that the administration, the normal ordinary administration of the state government is not being carried out in accordance with the law, right? In accordance with the provisions of the constitution. So this is clear-cut instance of failure of constitutional machinery. And when constitutional machinery fails, the proclamation of the president rule is being done by the president, right? तो ये एक coercive power है, ये obligation है state government का. आर्टिकल 356, आर्टिकल 365, इसको दोनों को आप याद कर सकते हैं. यूसी आर्टिकल 356, 6 को उधर शिफ्ट कर दिया, 5 को यहाँ पे शिफ्ट कर दिया, राइट? ये दोनों प्रेसिडेंट रूल की बात करते हैं, ठीक है? तो इस तरह से हमने पढ़ा कि स्टेट गवर्नमेंट इज बाउंड, ड्यूटी बाउंड टू अबाइड बाय द पार्लियामेंट्री लॉज. देयर enactments, their laws must be in consonance with the parliamentary laws. Their activities, their actions, their legislations cannot impede any executive measure, executive authority of the central government, or their legislations, their initiatives cannot be prejudiced against the executive authority of the central government. Otherwise, if this is not the case, if state government is violating these principles, then President of India is vested with the authority to proclaim the president rule in that particular area, right? In that particular state. Okay, let's move ahead and try to understand center's direction to states. This is number 3. Center's direction to state. Center gives direction to states at various instances. You see here, I have written here for you the 3 directions which are going to be issued by the central government to the states: to construct and maintain means of communication, road transport, railways, etc. Central government should, or very often central government shall direct the state governments to ensure the construction and maintenance of the means of communication. Means of communication, particularly the roads, the infrastructure, and the railways infrastructure, telecommunication, these all essential services. The central government can dictate the state to ensure the construction and the maintenance of these facilities, the communication facilities. And separately, the central government is vested with the authority to dictate the states or to advise the states to ensure the construction and maintenance of the railways. Particularly for railways, there is altogether different category. The second one is measures for the adequate facilities for instruction in the mother tongue. Central government shall dictate to the state that the state must ensure the facilities in their schools. The facilities must be available, or the adequate facilities must be available to provide the instruction, the education in the mother tongue, right? तो उनकी जो मदर टंग है, जो देसी भाषा है, ऐसी भाषा में बच्चों को इंस्ट्रक्शन मिले, उनको एजुकेशन मिले. प्रदेश सरकारों के अंदर जो स्कूल चल रहे हैं वहां पे ऐसा डिक्टेशन सेंट्रल गवर्नमेंट स्टेट को कर सकती है. और अगर स्टेट गवर्नमेंट ऐसा करने में नाकाम रहती है, स्टेट गवर्नमेंट इज नॉट able to provide the adequate facilities for the instructions to be provided in the mother tongue in the state government schools, then the central government can take action. Central government आपको पता है आर्टिकल 356 के अंदर प्रेसिडेंट को पावर है कि वो प्रेसिडेंट रूल इम्पोज कर सकता है. At the same time, drawing up of and implement welfare schemes for the scheduled tribal people. The scheduled tribe people which are there in the states, various states they are living, right? So states must take measures to ensure the welfare of the scheduled tribe people and to ensure the betterment of those scheduled tribe people. So this term is also shall be dictated by the central government to the state government. And in case state government fails to comply with these dictates put forward by the central government, then there is coercive action, article 356 and article 365. The president shall do announcement of the president rule. President shall deem that the administration of the state has failed and proper order cannot be maintained, the administration of the state cannot be carried out in accordance with the law. So in the name of the failure of the constitutional machinery in the state, the proclamation of the president rule shall be done, right? So this is coercive action enjoyed by the president. Here you see article 365. Be clear, these are the kind of foundations on the state government by the central government, imposed by the central government. Okay, let's move forward, and this is the fourth number, mutual delegation of the functions. There is provision in our constitution where mutual delegation of the function is ensured. Particularly if we talk about on union list, the central government makes laws and central government enjoys the executive power or the administrative power. As far as the state list is concerned, the state government is vested with the authority to make laws, and state government is duty bound to ensure the enforcement also. On the concurrent list, we have understood well that on the concurrent list, the laws shall be made by the parliament or the central government, but enforcement and the administration and the execution shall be done by the state government, as long as otherwise is not provided by the parliament. This is the rule. But it is not very tight mold. ये कोई tight mold नहीं है कि ऐसा ही होगा. अगर ऐसा होता तो आपको पता है डेडलॉक पैदा हो सकता है, हमारे एडमिनिस्ट्रेशन में कई बार समस्या पैदा हो सकती है. इसी वजह से हमारे संविधान में प्रोविजन किया है कि as far as the executive power or the administrative power is concerned, our central government and state government shall cooperate and collaborate and coordinate. वो लोग cooperate करेंगे, collaborate करेंगे और coordinate करेंगे, एक दूसरे की executive power को delegate कर सकते हैं. ऐसा प्रावधान हमने बनाया है, एक टाइट मोल्ड नहीं बनाया है कि वहां पे डेडलॉक पैदा हो जाए, वहां पे समस्या पैदा हो जाए. तो अपनी कन्वीनियंस के लिए थोड़ा सा हमने फ्लेक्सिबिलिटी यहाँ पे रखा है. और अथॉरिटीज का डेलीगेशन होता है, आप देखेंगे कैसे होता है. यू सी हियर, तो यहाँ पे हमने बताया कि टू अवॉइड डेडलॉक व्हाट वी डू, द प्रेसिडेंट विद द कंसेंट ऑफ द स्टेट मे इंट्रस्ट एनी एक्सिक्यूटिव फंक्शन टू द स्टेट गवर्नमेंट. The president can entrust any executive action or any executive responsibility on the state government with the consent of that particular state. तो हिंदी में समझिए, जो प्रेसिडेंट ऑफ इंडिया है वो कोई भी एग्जीक्यूटिव काम है, कोई भी एडमिनिस्ट्रेटिव काम है जो सेंट्रल गवर्नमेंट का है, वो उसका डोमेन सेंट्रल गवर्नमेंट में है. ऐसी परिस्थिति में प्रेसिडेंट ऑफ इंडिया कैन इंट्रस्ट एनी स्टेट गवर्नमेंट for that particular job, for that particular work with the consent of the state government. ठीक है, स्टेट गवर्नमेंट की कंसेंट मांग लिया कि भाई हमारा ये सेंट्रल गवर्नमेंट का काम ज्यादा है, आपके पास मशीनरी है, कॉन्टेक्स्ट सेंसिटिविटी है, एक्चुअली ये काम वहीं का है, तो आप ये काम हमारा कर दीजिए. If state agrees, then the central government can entrust that particular executive work on the state government. Is it clear? Let's come to the second one. At the same time, तो एक डेलीगेशन कहाँ से हुआ, सेंट्रल गवर्नमेंट से स्टेट गवर्नमेंट की तरफ. एग्जीक्यूटिव काम सेंट्रल गवर्नमेंट दे रही है स्टेट गवर्नमेंट को काम करने के लिए, अपना काम स्टेट गवर्नमेंट को दे रही है करने के लिए. एंड ये जो डेलीगेशन ऑफ द एग्जीक्यूटिव वर्क है ये कंसेंट के आधार पे हो रहा है. if state government agrees to discharge that duty, then it is okay. The converse is also true, ठीक है, इसका जो converse है, इसका जो उल्टा है वो भी सही है। तो अभी तो हमने देखा कि सेंट्रल गवर्नमेंट स्टेट गवर्नमेंट को अपने काम डेलीगेट कर रही है, पर्टिकुलरली एग्जीक्यूटिव वर्क्स आर बीइंग डेलीगेटेड विद द कंसेंट ऑफ द स्टेट्स। Converse is also true, right? Whenever governor or the state government feels that this work, this executive job needs to be properly performed by the central government, ऐसा लग सकता है कि ये सेंट्रल गवर्नमेंट सही से कर सकती है, ऐसी परिस्थिति में the governor of the state shall delegate that particular work to the central government with the consent of the central government. Central government की consent मांगी जाएगी और governor shall appeal to the central government कि आप हमारा ये काम करेंगे, कर सकते हैं क्या। If central government agrees to discharge that particular duty, that particular job, then फिर ऐसी परिस्थिति में वो पर्टिकुलर एग्जीक्यूटिव काम जो स्टेट गवर्नमेंट का है वो सेंट्रल गवर्नमेंट परफॉर्म करेगी। तो आपने देखा ये म्यूचुअल डेलीगेशन है दोनों तरफ से, और इसका बेसिस क्या है, कंसेंट। ये आप ध्यान में रखिए, ऑन द कंसेंट बेसिस ये एग्जीक्यूटिव वर्क का या एडमिनिस्ट्रेटिव वर्क का डेलीगेशन हो रहा है। ओके, सो दिस इज ओके। नाउ एक चीज हम और करते हैं, फ्रॉम द सेंटर द स्टेट के ऊपर भी काम हम डाल सकते हैं। तो सेंटर ने स्टेट को काम अपना दे दिया, एग्जीक्यूटिव वर्क दे दिया, एंड कंसेंट के आधार पे। एक आधार और है जब जहां पे स्टेट की कंसेंट की जरूरत नहीं है, ठीक है। आपको सवाल पूछना चाहिए, क्या सेंट्रल गवर्नमेंट स्टेट गवर्नमेंट को कोई ऐसा काम दे सकती है एग्जीक्यूटिव काम या एडमिनिस्ट्रेटिव काम करने के लिए जिसमें स्टेट गवर्नमेंट की कंसेंट ना हो? सो आंसर इज यस, ठीक है, आंसर इज यस। The central government can entrust any state government to discharge its executive work or the particularly administrative work without even the consent of the state government. This is a special case again, यहाँ से सवाल पूछ सकते हैं वो लोग, ये स्पेशल केस कैसा है? अभी तो हमने देखा कि कंसेंट की जरूरत है, वहां पे डेलीगेशन हो रहा है, यहाँ पे कंसेंट नहीं है। यहाँ पे टेक्निकलिटी ये है कि ये जो वर्क का डेलीगेशन होगा ये यहाँ पे स्टेट की कंसेंट की रिक्वायरमेंट नहीं है, लेकिन ये ऑर्डिनरी डेलीगेशन नहीं है, ये प्रेसिडेंट के एंड से ये डेलीगेशन नहीं किया जाएगा, ये गवर्नर के एंड से डेलीगेशन नहीं किया जाएगा, बल्कि ये पार्लियामेंट डेलीगेट करेगी। पार्लियामेंट कैन मेक लॉ टू डेलीगेट इट्स एग्जीक्यूटिव वर्क और द सेंट्रल गवर्नमेंट्स एग्जीक्यूटिव वर्क टू द ऑन द स्टेट गवर्नमेंट। पार्लियामेंट एक कानून बना के जो सेंट्रल गवर्नमेंट का एग्जीक्यूटिव काम है, जो एग्जीक्यूटिव या एडमिनिस्ट्रेटिव जॉब है, उसको डेलीगेट कर सकती है स्टेट गवर्नमेंट को। यहाँ पे स्टेट गवर्नमेंट की कंसेंट की जरूरत नहीं है, यूनिलैटरल प्रोसेस है। जो म्यूचुअल डेलीगेशन हो रहा था कंसेंट के आधार पे, हमने देखा ये दोनों तरफ से होता है, ठीक है। एक तरफ से सेंटर स्टेट ने डेलीगेट किया और फिर स्टेट ने सेंटर को डेलीगेट किया, बट जहां पे पार्लियामेंट्री लॉज के थ्रू डेलीगेशन ऑफ द एग्जीक्यूटिव वर्क होता है, देयर इज नो कंसेंट इज डिजायर्ड एंड इट इज यूनिलैटरल नॉट बाइलैटरल, राइट। ये यूनिलैटरल है, ओनली सेंट्रल गवर्नमेंट कैन इंट्रस्ट द स्टेट गवर्नमेंट टू इंश्योर द एग्जीक्यूशन ऑफ द सेंट्रल लॉज और द सेंट्रल एग्जीक्यूटिव मेजर्स बाय द parliamentary law. Converse is not true. The state government cannot make law in its state assembly and cannot entrust the parliament or the central government to ensure the enforcement of its executive job, right? ऐसा नहीं है। तो आप कुल मिला के समझिए, जहां पे कंसेंट के आधार पे मामला था, दिस वाज द बाई डायरेक्शनल, दोनों तरफ से हो रहा था कंसेंट के आधार पे, ठीक है, भाईचारा है इन लोगों में और ये लोग अपने अपने काम को, एग्जीक्यूटिव काम को डेलीगेट कर रहे हैं। बट जहां कंसेंट खत्म हो जाती है वहां यूनिलैटरल मैटर है, ओनली सेंट्रल गवर्नमेंट कैन डेलीगेट इट्स एग्जीक्यूटिव जॉब टू द ऑन द स्टेट गवर्नमेंट, और वो भी ये उस तरह का इनफॉर्मल डेलीगेशन नहीं है, बल्कि पार्लियामेंट्री लॉ के थ्रू ये डेलीगेशन होगा। इसमें भी स्टेट गवर्नमेंट इस तरह के कानून बना के पार्लियामेंट को कोई अपना काम करने के लिए नहीं बोल सकती है। दिस इज यूनि डायरेक्शनल। तो आप ये समझ रहे हैं, मुझको लगता है। लेट्स मूव अहेड एंड ट्राई टू अंडरस्टैंड द नेक्स्ट वन, which is cooperation between center and state. This is the fifth one, right? Cooperation between center and state. Our center and state government cooperate and coordinate with each other. You see, interstate water dispute, when interstate water dispute arises, then central government intervenes and central government tries to establish interstate water dispute tribunal, and through intermediation, through arbitration, central government tries to satiate the state concerned. Article 263, Interstate Council, the establishment of the Interstate Council to ensure the cooperation and coordination and a kind of cordial relationship between the various states. The central government is vested with the authority by virtue of Article 263 to establish the Interstate Council. The first Interstate Council was established in 1990. This is factual information. You keep this fact in your mind, right? The next one is full faith and credit. Full faith and credit shall be given to any legislation, any measure, any order across the India, right? So either the parliamentary law or the any state assembly laws, that those laws and those measures, those initiatives shall be recognized across the territory of India, right? This is also one of the clause. Next one is appointment of authority to ensure interstate trade commerce, right? And central government is vested with the authority to appoint the kind of authority or the power holder office which ensure the free interstate trade and commerce and ensure cordial and cooperative relationship between the center and state government. Now coming to the all India services. You see all India services I have written here for you. Earlier during the British time, these services were called the Indian Civil Services, you know well, Indian Civil Services, right? So these all India services are very popular in our country. We proclaim to be a federal country, but all the provision for the all India services we have made in our constitution, which is against the spirit of federalism. This all India services is the feature of the unitary system we have understood when we were discussing the federalism, right? So let's try to understand what are these all India services. See, basically all India services, there is a board for the recruitment, the Union Public Service Commission, which does the recruitment of the central government officials. At the same time, state government has also established there is constitutional provision in our constitution to establish the State Public Service Commission, right? SPSCs. And they are vested with the authority to do recruitment for the state officials, right? State के जो high officials हैं उनका recruitment State Public Service Commission करता है. Okay, so Union Public Service Commission does recruitment for the central services people. At the same time, Union Public Service Commission is vested with the authority to do recruitment for the all India services people also. These all India services are 3 in number: Indian Administrative Services, Indian Police Services, and Indian Forest Services. Right. So during the commencement of the constitution or during the British rule, the Indian civil services were very popular. So Indian civil services were named into Indian Administrative Services. Earlier ये Indian Civil Services करके इनका नाम था, and now the name is the Indian Administrative Services. And Indian Police was renamed as Indian Police Services. And in 1966, we created a new All India service, that is the Indian Forest Services. You see IFS. So IAS, IPS and IFS. IFS was created in 1966. These 3 services combinedly are called the All India Services. Is it clear? ये All India Services है. What about more All India Services? ये 3 ही All India Services हैं हमारे कॉन्स्टिट्यूशन में. क्या इससे ज़्यादा कुछ All India Services हैं? तो हमने जवाब दिया नहीं, बस 3 ही हैं. क्या इनसे कुछ ज़्यादा ऑल इंडिया सर्विसेज पैदा की जा सकती हैं, बनाई जा सकती हैं? यस. आर्टिकल 312 vests the Rajya Sabha with the authority to make a resolution for initiation or for creation of new all India service, right? तो आर्टिकल 312 ये प्रावधान करता है कि हमारी राज्य सभा जो अपर हाउस ऑफ द पार्लियामेंट है उसके पास ये अथॉरिटी है कि वो एक रेजोल्यूशन पास करके पार्लियामेंट को ऐसी पावर दे सकती है कि पार्लियामेंट कोई एक नई ऑल इंडिया सर्विस को इजाद करे, उसको पैदा करे, उसको बनाए. लेकिन अभी तक ऐसा हुआ नहीं है. अभी तक हमारे पास 3 ऑल इंडिया सर्विसेज हैं, नेमली IAS, IPS एंड IFS. इंडियन एडमिनिस्ट्रेटिव सर्विसेज, इंडियन पुलिस सर्विसेज एंड इंडियन फॉरेस्ट सर्विसेज. Is it okay? Okay, ठीक है. These are all India services. You see, ऑल इंडिया सर्विसेज के कुछ गुड एस्पेक्ट्स हैं, कुछ ब्यूटीफुल पॉइंट्स हैं, उनको हमको समझने हैं. ठीक है, देखिए ऑल इंडिया सर्विसेज का जो कंसेप्ट है, इट इज टोटली अगेंस्ट द स्पिरिट ऑफ फेडरलिज्म. इट इज अगेंस्ट द प्रिंसिपल ऑफ फेडरलिज्म. एट द सेम टाइम it is the feature of the unitary system of government, वो ठीक है, but there are so many beautiful aspects. Our all India services are working well. They are doing great service in the administration or in the execution of the policies. So some beautiful aspects of the all India services I have written here for you. You see, standards in administration. All India services ensure the standard in our administration. The second one is यूनिफॉर्मिटी थ्रू आउट द टेरिटरी ऑफ इंडिया. तो एक यूनिफॉर्मिटी थ्रू आउट द टेरिटरी ऑफ इंडिया इंश्योर की जाती है. एंड कोऑर्डिनेशन, कोऑपरेशन एंड जॉइंट एक्शन एज फार एज द इम्प्लीमेंटेशन ऑफ द पॉलिसीज इज कंसर्न. तो ये ऐसा है. These all India services, people are recruited by the Union Public Service Commission. They are trained by the Union Public Service Commission or the central government, and they work with the state government and the central government on tenure basis. ठीक है, वो state government और central government दोनों के साथ में काम करते हैं. This is very key position in the state administration. That's why they ensure the standard in administration, uniformity and coordination and cooperation, and they carry out joint action to ensure the enforcement of the policies of the government, right? So it is very crucial position. And now let's try to understand the Public Service Commission. Our central government has got the provision for the Union Public Service Commission, UPSC, and UPSC does the recruitment for the central government officials. At the same time, UPSC is vested with the authority to do recruitment for the all India services. We just understood this, right? So, you see chairman and members of the State Public Service Commission. At the same time, the State Public Service Commissions has been also constituted through the Constitution itself. There is provision in our Constitution to make provision for the State Public Service Commission and the Joint Public Service Commission, right? Two or more state can establish their collective or the Joint Public Service Commission and the State Public Service Commission. The State Public Service Commission people are vested with the authority to do recruitment for the state service officials. You see, chairman and members of the State Public Service Commissions are appointed by the governor. तो जो चेयरमैन एंड मेंबर्स हैं स्टेट पब्लिक सर्विस कमीशन के, इनका रिक्रूटमेंट किसके द्वारा किया जाएगा? गवर्नर्स के द्वारा किया जाएगा. बट दे कैन ओनली बी रिमूव्ड बाय प्रेसिडेंट. बी क्लियर. You see how central government is exercising its authority in the SPSCs. जो स्टेट पब्लिक सर्विस कमीशन है, इनके ऊपर सेंट्रल गवर्नमेंट किस तरह से अथॉरिटी एक्सरसाइज कर रही है. आप कंटिन्यूसली ढेर सारे फीचर्स आपने देखा कि हमेशा सेंट्रल गवर्नमेंट को एक अपर हैंड मिला हुआ है. सेंट्रल गवर्नमेंट स्टेट लिस्ट के ऊपर कानून बना रही है, सेंट्रल गवर्नमेंट इन स्टेट्स को अपनी एग्जीक्यूटिव पावर डेलीगेट कर रही है, सब कुछ तो कर रही है. तो हमने स्टेट पब्लिक सर्विस कमीशंस के अंदर अंडरस्टैंड किया कि द चेयरमैन एंड द मेंबर्स ऑफ द स्टेट पब्लिक सर्विस कमीशन are recruited by the governor, right? They are appointed by the governor, but the disciplinary action or the removal can be done only by the President of India. The second one is Parliament can establish the Joint Public Service Commission, on the request of two or more states. अगर दो या दो से ज़्यादा states आते हैं तो Joint Public Service Commission का provision जो हमारी सेंट्रल गवर्नमेंट है कर सकती है. At the same time, the Joint Public Service Commission chairman and members are appointed by the president, and they shall be removed by the president only, right? The next one, Union Public Service Commission can fulfill states needs when two or more states request to the Union Public Service Commission that they should do recruitment for their state officials. The Union Public Service Commission can assist them in the recruitment, right? तो यूनियन पब्लिक सर्विस कमीशन उनके लिए ऑफिशियल्स का रिक्रूटमेंट कर सकता है. The last one is Union Public Service Commission can assist any state if a state request to UPSC that they assist the state government to do some kind of special recruitment. तो वो पॉलिसी फॉर्मुलेट करके दे सकते हैं, क्वालिफिकेशन बता सकते हैं, या कुछ स्पेशल नीड्स के लोग चाहिए ऐसा करके, देन यूनियन पब्लिक सर्विस कमीशन कैन असिस्ट द स्टेट गवर्नमेंट in the recruitment of their officials. So this much we have done, the public service commission we have understood. Now we are coming on the integrated judiciary. We are a federal country, despite the fact that we are a federal country, but we have not established the separate judiciary. If we are ideally federal country, then we would have established not the integrated judiciary but divided judiciary. You see, the divided judiciary, by I mean central or the supreme judiciary, the federal court should have been there, and for the state courts would have been there. But it is not the case with our India. We have established one integrated judicial system. The Supreme Court at the top of the hierarchy, and at the intermediate level there are high courts for the various states, and at the lower strata there are the subordinate or the district courts. And this one integrated judicial system enforces the central as well as the state laws. So one integrated system of judiciary is there, and that judiciary is vested with the authority to ensure the enforcement of the central laws as well as the state laws. Our judges of the high courts are appointed by the president with the consent of the governors and the Chief Justice of India, CJI governor. So in with the consent of governors and the CJI, our president appoints the chief justices and the other judges of the high court. But they can be removed only by the president, right? Their removal shall only be done by the president. So the chief justices of the high court and other judges of high court, they are appointed by the governor, they are appointed by the president on the advice of, on the recommendation of the governor and with the consultation with the chief justice of India. But they can only be removed, the judges of high court I am talking about, they only can be removed by the president. You see, again our parliament or the central government is enjoying, you know, upper hand. So the judges of high courts can only be removed by the president of India. You see, the second one is parliament can establish common high court for the two or more states if requested by the two or more states. The Goa and Maharashtra, they are currently having a joint high court, and Punjab and Haryana. Let's move ahead and try to understand relations during emergency. You see, Article 350 to Article 356 and Article 360. These are the emergency provision. You know, Article 352 talks about the national emergency. Article 356 talks about the president rule, and Article 360 talks about the financial emergency. So during these emergencies, when national emergency is in force, then all powers of the state governments get suspended. Our federal system suddenly becomes unitary, even without a constitutional amendment, right? So you try to understand each and every aspect of the administration, the execution and everything, even the legislative power shall be enjoyed by the parliament or the central government. What about the president rule, Article 356? When president rule is imposed on any particular state, then the ground for the imposition of the president rule is that, you know, the state government has failed miserably to comply with the advice or the the recommendation put forward by the central government. In this scenario, the president is of the mind that the common administration of the state cannot be carried out in accordance with the law. The constitutional machinery has failed in that particular state. So this becomes the ground, and the president rule by virtue of Article 356 is imposed on that particular state. And in this scenario, the parliament starts enjoying the legislative power on the state list in that particular state, and all the executive measures, all the executive actions shall be taken by the, can be taken by the parliament or the central government. Article 360, financial emergency, again the sweeping power goes in the hand of the central government and the parliament. Other provisions are also there in our constitution. You see some of the provisions I have written here for you. Article 355, center's obligation to protect external aggression and in accordance with the law. Article 355 ensures a kind of obligation on the central government, and central government is obliged to protect the states from any external aggression. So it is obligation on the state or on the central government to protect, to ensure the protection or the security from any external aggression on the states, right? And again, the state governments are obliged to abide by the each and every dictates or the each and every advice tendered by the state government, central government, right? So this is one. And the second one is governor as agent of central. Governor are appointed by the President of India, right? And on the recommendation of the central government. And governors basically work as an agent of the central government in the states, because they can only be removed by the president. Their office follows the doctrine of the pleasure. So during the pleasure of president, our governors enjoy their office. So this is also we have done. Election commission of states, though appointed by the governors, right? Though appointed by the governors, but they can only be removed by the president. You try to understand. Election commissioners of the state government, you know, state government election machinery is altogether different from the National Election Commission. So the election commissioner and the chief election commissioners of the state shall be appointed by the governors, though they are appointed by the governor, but shall be removed only by the president. Be clear, president के द्वारा ही उनका removal होगा. Now the last one is extra constitutional devices. There are several extra constitutional devices to ensure the cordial relationship between the executive relationship or administrative relationship between the central and state government, which some of them I have written here for you. You see, advisory bodies. This in true broad categorization we can divide these instruments or these kind of constitutional non-constitutional devices. Advisory bodies and conferences. If we try to talk about the advisory bodies, you see the Niti Aayog, you know, the planning commission, erstwhile planning commission, and now Niti Aayog. National Development Council, National Integration Council. There are so many councils, so many bodies, advisory bodies are there. To name a few, let me read for you. Planning Commission, erstwhile Planning Commission, now Niti Aayog. National Development Council, National Integration Council, Central Council of Health, Central Council of Central Government and Urban Development, Zonal Council, Northeastern Council, Central Council of Indian Medicine, Central Council of Homeopathy, Central Family Welfare Council, Transport Development Council, and University Grant Commission. So there are numerous councils which are there to do the advisory work. At the same time, there are conferences which are held to ensure the cordial relationship between the central and state government. Governors Conference, Chief Ministers Conference, Chief Secretaries Conference, Inspector or Generals Conference, Chief Justices of India's Conference, Home Ministers Conference, Law Ministers Conference. So there are various conferences which are held. These are extra constitutional bodies which ensure cordial relationship or the coordination and cooperation between the central and state government. So at least now you try to understand. It is clearly said that we follow a kind of cooperative federalism. We are not kind of ideal federalism which is there in the USA, almost ideal. Yes, it is reality that states has lost their right to secede. उनको स्टेट्स को बाहर जाने का अधिकार वहां पे छीन लिया है. अगर वो भी होता तब उसको आइडियल फेडरलिज्म कहते हम. लेकिन फिर भी जितने भी फेडरल सिस्टम्स अवेलेबल हैं धरती पे, पृथ्वी पे, उनमें से अगर बात करें देन यूएसएस फेडरेशन इज द बेस्ट अवेलेबल फेडरेशन. तो वैसा भी फेडरेशन हमने नहीं बना पाया है, क्योंकि आपने अक्सर देखा जहां जहां पे हमने पढ़ा, प्रेसिडेंट, सेंट्रल गवर्नमेंट, पार्लियामेंट हमेशा प्रिवेल कर रही है. ठीक है, तो हमने जानबूझ के इस तरह का सिस्टम इजाद किया है अपने यहाँ पे. तो ऑर्डिनरी सर्कमस्टेंसेस में वी आर फेडरल कंट्री, but during the extraordinary conditions or during the when special needs are there, then we suddenly become the unitary system even without the constitutional amendment. तो deliberate attempt है ये हमारा, इस तरह से हमने किया है. So in this way we have understood the administrative relationship or the executive relationship between the central and state government. And in our tomorrow's class we shall try to do the financial relationship, or you can study the financial relationship on your own. Goods and services tax concept has come into the picture. So you can, if you can study on your own the financial relationship which is enjoyed between the central and state government, then we shall try to start a new chapter altogether, which is, I think, the constitutional amendment, not constitutional amendment, the emergency provisions, I think. So we shall do that tomorrow. Thank you for watching. If you like our videos, like if you feel like you have got derived any kind of assistance, any information from our videos, you can subscribe our channel, you can like our videos for more reach, you can subscribe our channel, of course, right? And you can share our videos with your friends and families. Thank you so much. Best of luck here for your preparation. Thank you.